Hey everyone, I hope you're doing well and staying safe during this time. If you're new here, welcome to the channel. Like I said, thank you so much for checking me out. If you haven't done so, please make sure to hit that subscribe button just right below the video. Cool, thank you so much. I really do appreciate it. And if you're returning, welcome back. Thanks again for your support. I truly do appreciate having you here.
XRP lawsuit. Here's why you should be paying attention to the SEC v. Ripple case now. With Russia hit by sanctions and being cut from the SWIFT system, many crypto watchers in the past few days have been talking about XRP's place in the banking world, and the legal tangle of SEC versus Ripple. Verdict to come in a SEC? During an interview on Fox Business News, Ripple CEO Brad Garlinghouse shared his thoughts on the progress of the SEC versus Ripple Labs case. It has been a hectic few weeks of unsealed memos, and despite the ongoing war, the XRP community was eager to know whether things were looking up for the controversial crypto asset. For his part, Garlinghouse expressed that he felt clarity was coming. He said, "And so the case continues to move forward. We're expecting some decisions from the court, sooner rather than later, as it relates to a couple decisions before the court, but look, it's moved slowly." The exec also made sure to criticize SEC Chair Gary Gensler's comparison of the crypto industry to the Wild West. Of course, the interview couldn't end without covering the Russia-Ukraine war and the question of sanctions. On this subject, Garlinghouse claimed that some crypto critics did not have enough knowledge about the way the technology worked and were expecting a blanket ban in sanctioned countries. Furthermore, he stated that Ripple was a responsible actor working with the U.S. government. A boost of confidence. It's not just Garlinghouse who is optimistic about the Ripple vs. SEC timeline. Crypto lawyer John Deaton, representing tens of thousands of XRP holders in the case, also echoed the Ripple CEO's opinion about a result coming soon. What's more, he expressed his confidence that unsealed evidence relating to the Hinman emails would help bring about a settlement or even a favorable verdict for XRP investors. About a possible ruling, Deaton explained. "Earlier I said either today or Monday. If it's not Monday, I will be shocked if it's not filed by the end of next week." XRP lawsuit. Ripple execs should thank SEC for suing them individually. It seems the SEC is throwing this DPP Hail Mary and hoping that Judge Torres bails them out on appeal. Hasn't that been the case lately? Nonetheless, Ripple Labs and its execs are continuing to clamp down on a potential win against the regulatory watchdogs. On 11th of February, Ripple Labs filed a letter motion to compel the SEC to turn over notes. These notes pertain to 2018 meeting between Brad Garlinghouse and former Commissioner Elad Roisman. As expected, however, the plaintiffs refused. And in doing so, the SEC claimed they were privileged. Everything has an expiry date. That wasn't the end of it though. On 28th of February, CEO Brad Garlinghouse filed a response to the SEC's opposition to his motion seeking the disclosure of the notes, the Estabrook notes. The SEC called privilege, but the defendants think otherwise as reportedly, under the court's January 13, 2022 ruling, the Estabrook notes aren't privileged and should be disclosed. In fact, the SEC's opposition was spent trying to equate the Estabrook notes with those taken during a 2019 meeting, one that involved a third party. To many, the SEC seemed to ignore the core reasons cited by the exec. According to the doc in question, Garlinghouse seeks disclosure of the Estabrook notes since they are likely to corroborate his account of a discussion that he had with a commissioner of the SEC regarding the regulation of digital assets, an issue that goes to the core of the SEC's knowledge or recklessness allegations against him. The SEC's argument is that it has no proof for disclosure of the Estabrook notes. In fact, it stated that this would invade the Commission's policy-making process, adding that a purpose of the notes was to allow Mr. Estabrook to provide advice to Commissioner Roisman on a potential future proposal by the Commission of a rule regarding the regulation of digital asset offerings. The exec believes that the SEC's attempt to defend its sword and shield tactics is unconvincing. Furthermore, Garlinghouse requested the judge to deny the watchdogs from engaging in such tactics. If the judge grants this motion in favor of the defendant, this would hint at a possible win for Ripple. John Deaton, founder of Crypto Law, shared the same optimism as many. Jeremy Hogan soon chimed in as well, with the attorney sharing a few possible scenarios in an attempt to critique the SEC's next moves. Curiously, according to John Deaton, Ripple should thank Jay Clayton for suing them and creating a higher burden of proof on the SEC. By suing them individually, the SEC made these notes much more relevant and quite possibly necessary. There's always an if. As has been the case during previous disputes over the SEC's documents, The plaintiff refused to produce them over claims of deliberative process privilege. Would this repeat itself? Well, even if this transpired, Garlinghouse might just win.
I'm your guy. I will keep you posted. I'm your advocate. I'll be back on a daily basis, usually multiple times per day, with these videos to keep you updated with everything going on. So, I hope you enjoyed the video. If you haven't done so, make sure to hit that subscribe button. Feel free to share any of my videos with your friends, family, social media, or anybody who may care to listen. Thanks so much for your continued support. I'm always here for you. I want to help you through this time. So thank you so much for continuing to choose me. Enjoy your day, stay safe, and I'll catch you again probably in a couple hours. Thanks, everybody. See you later.